Good afternoon, everyone. It is 4:02 in the afternoon, and I am calling this Executive Committee meeting of the Community Oversight Board to order. I'll start by reading the appeal statement. Pursuant to the provisions of Section 2.68.030 of the Metropolitan Code of Laws, please take notice that decisions of the Metropolitan Government of Nashville and Davidson County Community Oversight Board may be appealed to the Chancery Court of Davidson County for review under common law writ of cert. Any appeal must be filed within 60 days after entry of a final decision by the board. Any person or other entity considering an appeal should consult with an attorney to ensure that time and procedural requirements are met. I think I can establish quorum here. I'll do a roll call here. I see Mr. Kalmagooch, I don't think is with us yet.
Not yet.
Yep. And Ms. Ross?
Here.
And Mr. Sweeney?
Here.
All right, so I will pass it over to Mr. Pinkley for the electronic meeting statement.
Thank you. I'll keep it short. The electronic meetings were created by Executive Order 16 in March of 2020 in relation to the COVID crisis. That has been extended by Executive Orders 34 and 51, and most recently Executive Order 60, which is set to expire October 28th. So for today's meeting, we just need a motion and a second that we're going to meet electronically to conduct essential business to protect the safety and welfare of Tennesseans.
So moved.
Second.
Thank you. Any focused discussion on that? There is none. I'll take a roll call vote here. Mr. Kalmagooch, still not on. Ms. Ross?
Yes.
And Mr. Sweeney?
Yes.
And I vote yes as well, so that passes. I think next is the minutes, so I will take a motion to approve the minutes.
So moved.
Do I have a second? Thank you, Ms. Ross. Any focused discussion on the minutes? Anything that you saw that needed to be corrected? If there is nothing, I will do another roll call vote here. Mr. Kalmagooch still isn't on. Ms. Ross?
Yes.
And Mr. Sweeney?
Yes.
And I vote yes as well. So the minutes are approved. And we just get right into it here. I know there's a lot of important things to discuss, including what may be the final version of the updated MOU with Mnpd. So I'll also remind you all that at the last board meeting, the board voted to delegate authority to the executive committee to approve the new MOU between the COB and the Mnpd, as well as the MOU among the COB, the Mnpd, and the district's attorney's office. However, since we only just received the updated MOU this afternoon, with the updated MOU between the COB and the Mnpd, I think we're probably going to defer that to approving that until the next full board meeting. But Director Fitchard can give us an update on all that has been happening with the MOUs.
Okay, thank you. I'm going to talk about the first MOU with the District Attorney General, and that MOU is ready. When we talked about it at the last meeting, the appendix needed to be attached. They have that, and I sent all of that information to you. It is ready to go. There was, I think, the information regarding this, how we were going to the COB, the portion where it said the COB will provide to the DAG office a narrative summary and the recorded interviews, and that would be on or after the 61st day of the COB's investigation. That language was in there, added to the final document, and it looks like hold on one second. It looks like Interim Chief Drake has signed off on it already. And so they were waiting for Chair Martinez and myself to sign off on it. And then it would go to the District Attorney General's office for signature, and then to the legal, to Metro Legal, and then it would be filed. So that is ready. And if you guys want to approve that, there's no changes to it. I sent it to you so that you could see the final draft, and it is ready for approval. Unless you guys had any questions about it.
Mr. Sweeney,
I would move for its approval.
I second. I have no changes to it.
great. Will any focused discussion on that? I don't think there will be, but I'll just check. So I will take a roll call vote to approve the MOU among the COB, the DA, and the Mnpd. Mr. Campbell-Gooch, I don't believe is here yet. So Ms. Ross?
So moved.
That's a yes, right? Yeah.
Yes.
And Mr. Sweeney?
Yes.
And I vote yes as well. So that is approved, and I will then sign it on behalf of the board. Anything you want to add to that, Director Fitchard?
No, that's it. Thank you so much.
Great. So we can move on to the MOU with Mnpd.
Okay. So yesterday we had a negotiation meeting where Dr. Hildreth, Ms. Hildreth, was the negotiator, the designated negotiator for the COB. We had our meeting yesterday at 3:30. In that meeting was myself, Dr. Hildreth, myself, Metro Legal, Bob Cooper, and Cindy Gross, who's the legal advisor for Mnpd. There was John Bunton from the mayor's office, as well as Deputy Chief Hagar and Acting Chief Drake. And so this was the second meeting, and this meeting, they brought the revisions that we had talked about in our first meeting, this was actually the document that I sent to you just a while ago is the document that included our revisions as we negotiated in the first meeting. And so I know you guys didn't have a whole lot of time to review it because I got it kind of late. And so I didn't know how you wanted to proceed, if you wanted to go through it and talk about any of the revisions or the language, or how you want to proceed. Or if you just want me to go through each section, I can. There wasn't a whole lot of language change in this document, but there were some changes that if you want me to clarify, I will.
Mr. Sweeney?
Yes, I'd suggest that we walk through and just point out the changes that have been made and whether you agree with them or don't agree with them. And if you don't agree with them, why?
Gotcha. Okay, so in section 1 of the introduction, there was language change in the very the very last paragraph where it says the department in Mnpd. So that used to read the Mnpd. That was a change. So what they did throughout this document is they went back to taking the term Mnpd out and replacing it with the department. And they also removed the MNCO and replaced that with the COB, because of course the COB is what's named in the charter. And so in the definitions under COB, which is in section 2 under definitions, they removed the word MNCO and they put in the Metropolitan Nashville Community Oversight. So the COB in that section encompasses the staff, and they are labeled as the Metropolitan Nashville Community Oversight staff. And so when you see COB, they don't use the terms interchangeably. They just call it the COB, even though it's not the COB that's going to show up to a crime scene. It's going to be the COB staff. So that was one change, and we accepted that. The next change was under section, hold on one second. I want to get all my forms mixed up. The next section would be in section 4 under cooperation and access to records and information. And so in this particular section, at the very top of that section, they changed the language a little bit. We had a mistake in our draft where we had in advisory report, so that was removed. And then in that particular first paragraph, the language that was removed from that paragraph where it read, these policies will assure, there was a, equivalent and contemporaneous. COB, we had COB and OPA access. So they removed OPA and took out equivalent and contemporaneous. And they also took out the language consistent with provisions. I'm sorry, such access to the department's documents and information will not require an open records request. So they kind of cleaned up the language because we now have this agreement with the department, with the district attorney's office. So that kind of changed some of the language around. But I accepted that change because I felt like that made sense because of what they were talking about in that particular section in the first paragraph also kind of was supported by the DA's MOU. When we get down to on page 4, it talks about the database section where it used to read intranet access. And so what they explained to us was that the intranet was the they were connecting into the access to TBI's CGIS was in that system, which is a federally backed system that we would not be able to have access to because we're not a law enforcement agency. And so what we were actually wanting was this database access. And so that database access was included in here. And then what we did was we sent over a list of the database and the information that we wanted to be included in that database. And so that's some of the things that you see here. And then of course, if we need to ask for more access to data, then we would just let them know through the Mnpd, researchers or the analysts or whoever creates these weekly folders for us to add that information in there. And so I think that is, I had Dr. Valier let me, tell us what things that he needed to have, regular access to be able to do his job and function in his job. And so that's what you see under Section D, database access. When we get to E, on that section, there was some information that was taken out, a lot of information that was taken out. And I think that they say things in here. So there is something that I just realized that I didn't see it when I was talking with them yesterday, where they say here, otherwise protected by TRCP 16 and release of those records directly to the COB. Now, it's from my understanding, Rule 16 does not apply here. And so they have that information in there, and I am going to ask them to remove that because we had already had a discussion, and that's in the District Attorney General's, that's in the DA's MOU, where it's not, this information is not protected by Rule 16 unless it's under the caveat of those that are listed in the appendix. So I think that this needs to be changed. And so I am going to request that they make that change before we accept that. And then if you guys have any questions about that, you want to jump in and ask those questions now, or you want to wait to the end?
One thing, I went back and looked at the DA's agreement, and the DA's agreement resolves the issue of Rule 16, but it doesn't specifically say that it doesn't apply. So maybe one way of addressing this is in some language that I sent you earlier that would say, instead of saying otherwise protected by Rule 16, saying that the agreement with the DA's office resolves any concerns about TRCP 16.
Okay.
And that way we're not conceding application of Rule 16, which I agree with you does not apply. Mm-hmm. But to the extent that there were concerns, they're resolved by the DA's agreement. And then I would more specifically identify the DA's agreement when we get a final date on it, when the parties signed off, and I would attach it as an exhibit to this agreement.
Okay, that makes sense. Okay, anyone else have any comment about that? Okay, and so moving on to the section of confidentiality, in B of confidentiality, there was some language added in B. That last sentence in B says records provided under section 4E are designated as confidential. So basically, if it's designated as confidential, we'll keep it. It says the document shall mark, or the department shall mark or otherwise clearly designate what documents or information it is providing to the COB that are confidential. Records provided under that particular section 4E are designated as confidential. And that they put that in there so that they wouldn't have to stamp or document each particular item. And so that's, go ahead, I'm sorry.
I have a concern as to whether we, when you're doing a report, as to everybody, knowing what is and what isn't confidential, it's not stamped or otherwise marked or designated in some way. I mean, what stuff are you going to know that's clearly coming in under E as distinguished from some other way? Because basically what E says is we don't have to worry about it anymore. All we have to do is request things and they're going to come to us unless there are those protected statutes. So that seems to say to me that every document we get is going to be confidential, which I know isn't right.
Right. So I think that cases that are open, based on the agreement with the DA's office, what we've been doing is just asking them, what our legal advisor's been doing is if we get a request for records to be released, he has been asking them if those cases are still pending and open, or if that information can be released. And that's where that information, whether or not we can release it, has been coming from.
But that's not saying anything about whether what we receive is confidential. And that's not what this provision says. I don't want us to get in a situation where we mistakenly release something that we don't think is confidential and the police department thinks it is. So I think it's important for us to know that what we're getting, the Mnpd believes is confidential.
So I guess what I could do is we could ask them once they send it to us to let us know that it's confidential. And that's what this is basically saying anyway, that we want them to
designate. That's why the marking provision is in there, which is still in there. That hasn't been taken out. They've just added another sentence, but it doesn't say that, other doesn't take out their requirement to mark stuff.
That's correct. So I'll just get more clarity on that. I think that we did ask them to leave that in there. So I just need to know how they're going to do it.
Yeah, I think it's important that they understand that we want to make sure that we both are on the same page as
Right.
to stuff that we get, as to whether they consider it to be confidential, so that we can properly protect it. But if they don't mark it or somehow otherwise identify that it is, then there's a risk that we may inadvertently release it because we don't recognize it as confidential.
Yeah, I agree with that. I think that we had, I'm trying to think back to the conversation we had about it. And so I think that, you know,
May I?
yes. Oh, I didn't know you were there. Yes.
Good afternoon, everybody. Phyllis Hildreth, I'm sorry that I'm late. I had marked there that you had revisited on our, I'm sorry, so let me give you my method. When we went through our markup copy on the negotiation meeting of September 28th, I have handwritten notes around that, and then we compared them with the meeting we had yesterday. And there, Jill, and I'm wondering if this goes to Member Sweeney's concern, that the opening sentence of section 5, paragraph B, the department shall mark or otherwise clearly designate what documents or information it is providing to the COB that are confidential. That was meant to be controlling. So I thought I heard the conversation at the table as acknowledging Member Sweeney's concern that the police department did need to flag and indicate so that we did not underestimate the severity, because the notion of confidentiality comes up later when we look at the section of where the interviews will be held, and COB may take photographs unless the person being interviewed was undercover, and therefore, again, a concern for confidentiality. They raised it, and we said that we would be looking for their lead to hear it. So, Jill, I don't know if that helps you, but that's the way.
I was trying to remember. I mean, so many. Yeah, I have my notebook with me.
And there were a lot of places where there seemed to be functional agreement that is not as clearly in the language of the MOU, so that there are almost legislative intent comments that are happening. Jill, I don't know if you mentioned that beforehand, or if you're going to do that afterwards, that that's something for the executive committee to think about, is how much other clarifying language that's not in the language of the agreement document is helpful or could be misdirecting. But anyway, I will mute myself and go back to listening. Thank you.
Thank you for that.
Ms. Ross, see your hand up.
Yes, I agree with Mr. Sweeney that we should have something marked confidential prior to us receiving.
Yeah, and I think that that's what Ms. Hildreth just alluded to. I just couldn't remember exactly what the conversation was about. So did that answer your question, Member Sweeney?
Yes, but I don't know how to read the two sentences of B together.
Yeah, I agree with that. All right, so that's something that we need to go back and revisit with them, and maybe create some other language regarding that. So, but it looks like the marking is going to happen, and then I need to figure out why that little records provided under section 4 are designated as confidential is in there. So, all right, any other questions about that section? If not, then I'm going to move to the intake investigations. And under intake investigations, under A, section 2, there was a word that was replaced. If you see, it says failure to comply may be grounds. We initially had will be grounds for disciplinary action. And so we changed it to may be grounds for disciplinary action. I did have some questions about that change when we brought it up. And, I wanted to just have some clarity in regards to if a officer is not compelled to cooperate, and they fail to cooperate, what is the repercussion? You know, do they just say, okay, I didn't decide to cooperate, the COB, and so, you know, there's nothing that happens. And so the failure to comply, instead of saying will be grounds, is may be grounds, just because there could be, what they said was that there could be a misunderstanding that they were supposed to come in and interview with us. They could be out of town. And so, you know, they could be, you know, on military leave or something of that nature, or they would not be at that time available to comply. And so I accepted that as, I accepted that may instead of will, because there's policies for violations of not cooperating, and they also said there were 2 policies regarding that in their manual. So, because I guess my comparison to them is, will they have to always comply with the OPA? And they said yes. And if they don't, then that's a civil service violation as well as an Mnpd policy violation. So, any questions about that one?
Yeah. Can it be made clearer by adding another sentence that says something like, however, intentional refusal will be a ground? I understand the reason for may. I mean, things happen. But it seems an awful loose if there's just an intentional refusal to cooperate.
May I chime in?
Yes.
So we were told that intentional refusal actually violates 2 of their policies that we have access to, and I guess oversight. So since if there was an active refusal and if we become aware of that, can we not call that out as part of our oversight function? Does it require further elucidation in the MOU?
Well, I would presume that if we're going to bring a charge against them for violation of another regulation, as to that violation, we'd have to start over again and give them notice of a violation. Where if it's in here that there is a duty to cooperate.
Okay.
And
So to ask for language that highlights their internal duty to cooperate,
yeah,
and chapter and verse.
Yeah, and maybe say there's an internal duty to cooperate as required in Mnpd regulations, you know, blank through blank.
Okay.
And then the failure to comply would be fine.
Got it. Thank you.
Got it. And then there was above that, or the sentence right before that was added. It says, shall respond to the notification within the time period. And there was a little note off to the side that said recommendation reminder that COB SOP should reflect similar notification procedures as OPA to ensure consistency. And so that was added. You know, that's, I didn't have a problem with that one. Okay. All right, and going to section. All right, so I'm sorry, to number 3. In number 3, there was, instead of saying, we had in the original, we had and typically instead of which in the second sentence. So the executive director or assistant executive director will determine the location of the COB interviews, which will take place at the COB office currently at the location. and then it says, or other metropolitan government or other metropolitan government facility. All interviews will be audio, video recorded. And then when we got down to the photographs part, the photographs of an employee may be taken if such photos are pertinent to an administrative investigation. And then they added language that says such photos will be treated as confidential until and unless the department authorizes their public release. And they gave the example of having, you know, an officer who was undercover, an officer who was under investigation, and so forth as the example. And so we accepted that language. You know, my concern was if an officer, you know, we might want to photograph injuries or bruises, and you know, and so they just said, just, you know, in order to make this work, that we would just call them, you know, to get information on whether or not this officer, if this information, I'm sorry, could be released. And so we agreed to that. Is there any questions about that? Okay. All right, so in the next section, which is notice to employees, if you go down to B and you go to under 5, letter D, I'm sorry, 5, number 5, letter D, the language in that is changed. So if you've received a direct order from the department chief of police to cooperate in this investigation, any statements made by you during these interviews cannot be used against you in any subsequent criminal proceeding, nor can the fruits of any of your statements be used against you in any subsequent criminal proceeding. And that is the Garrity function there. So when an officer is compelled, and that is the Garrity warning. So, or the Garrity, they're Garrity protections. And so that language was changed slightly. And in number 6, they added the language where we initially had employee attorney, but they added counsel during an interview as the introduction to this particular paragraph. And so it's just basically saying that an employee may have an attorney, a group representative, a supervisor, or a personal representative with them during the COB investigative interview, but that representative cannot be involved as a participant in an interview as a witness. But they would, you know, if they took a break, they could confer with their attorney, not during the middle of questioning, but if we're having a long episode of interviewing and they decide to take a break, they could also take a break and confer with their attorney or their representative at that moment.
I see some hands up. Mr. Campbell Gooch.
Oh, I'm sorry.
Hey, everybody. I had a real quick question about the Garrity Clause in 5D.
Yes.
If you can kind of game that out, how that might play out in real time.
Well, so what we did was all officers are afforded their Garrity rights. And Garrity basically is where there's no self-incrimination used. What we do in an administrative investigation cannot be used in a subsequent criminal investigation. It's sort of like your, you know, in a criminal investigation, you have what you have, like Miranda rights, you know, for self-incrimination. So Garrity rights are where all officers are compelled to cooperate and tell the truth about an investigation, but the information that is in that administrative investigation or gleaned from that investigation cannot be then used in a subsequent criminal investigation. The information that they shared cannot be used against them.
Mr. Sweeney.
You previously sent something around that advised us that, I guess it was the comments that came with the earlier draft that said we need to take the Garrity provision out because that's only an employer-employee issue, and we're not an employer, and therefore we can't have Garrity. So how does that relate to what's in here now?
So I sent the Garrity form over to Chief Hagar to look at, to make certain that Garrity, what we created was something that that, you know, it had the language that they were the language that they were originally concerned with, that we were able to put this language. This essentially the Garrity, what is in the Garrity form is what you see here, A through F. And so the issue was we were reading the Garrity form to officers who had not been compelled, right? Like a person that might just voluntarily come in. And so the Garrity the protection is not afforded to them unless they are compelled by the chief of police to cooperate with us. And so that is why this is in here.
Okay, so if I recall right, and I may not, in several early investigations that we had, officers invoked Garrity and said that they wouldn't be interviewed. Is that true? My memory right?
No. So what was happening with that, if I can recall, is the issue wasn't around the Garrity warning. They couldn't do that. No, the issue was the location of the interviews.
Okay, so nobody has previously cited Garrity and refused to be interviewed by us.
No, not that I'm aware of. No.
Okay, all right.
Chris, let me ask Mr. Clause. Let me ask Mr. Clause.
Okay. Yeah, I'm not aware of any of that. That hasn't happened since I've been here either, Jill.
Okay, all right. So my memory is just wrong. So that's good. That's fine. If somebody comes in to be interviewed and they decline to be interviewed, how do we get the chief to order them? Or is that just something that the individual has to do, and why would they do it?
I'm going to let Chris, Mr. Clause, you want to answer that?
Sure. The reason they're asking to be compelled by the chief is because their Garrity rights are not provided to them unless they ask to be compelled by the chief. So that's the reasoning behind them asking for to be compelled.
And what if they just decided to be silent and not ask the chief to compel them?
Then they're not cooperating in the investigation, and that would be a report back to the chief that the individual was not cooperating or did not cooperate.
Okay. So cooperation means that they have to provide us with information?
Yes.
Yes.
Okay.
Right, and that kind of goes back to that violation that we talked about a few minutes ago, that there were two policies regarding cooperation, and that is under the civil service as well as Mnpd's policies, and it's a policy to failure to cooperate with an investigation, and which could lead to termination. Did that answer your question, Mr. Gooch?
Yes, it definitely did. And that was my main concern. Any type of I didn't know how to flag manipulation or just ways that folks can use the Garrity rights to not be investigated. So it did answer my question.
Understood. Thank you. Okay. Now I've got to figure out where I am.
Just if I can jump in real quick, just while there's a break. If we could have the board members and staff identify themselves before they start speaking, I think that would help keep the record clear. And I think that is a requirement under the new provisions for the month of October under Executive Order 60. So if you guys don't mind stating your names before you start speaking.
Okay, thank you for that. And so if we go down to the next section, I'm in C, we're in, just so that everyone knows where we are, it's, we are in still, let me see, we are in section 6. We're on page 6. All right, we're going to page 7 under concurrent investigations. It's letter C. There was some language added in number 2. So number 2 is neither party shall discourage potential witnesses from cooperating with an investigation by the other party. And so I agree with that. And that's under the concurrent investigations, because we know that from time to time, the department, which is OPA, or the police department in general, and the COB will be conducting concurrent investigations. And so I think that statement that's fine with me to be added. Did you have any questions about that, Mr. Sweeney? Oh, I'm sorry.
This is Sweeney. No, I forgot to take my hand down, so.
Okay. All right, so in section 7 under mediation and restorative justice, they basically want us to do deconfliction. And one of the things that they said about the deconfliction, and I haven't decided whether to add, this is something that Dr. Hildreth had just mentioned, that these are some notes from the meeting yesterday, what we discussed in regards to mediation. So one of the things that I think that we need to talk about is this: prior to mediation, deconfliction should occur. And I'm going to talk about an instance that happened in real time with us. There may be concurrent investigation or prior investigation and mediation. For example, the MNCO may attempt to mediate a matter that the Mnpd would prefer to address differently. Similarly, the Mnpd may have no notice of prior mediation with MNCO and thereby affect the ability to address potential second or repeat offenses. And also it says, similarly, what if OPA mediates an issue and the complaint goes to MNCO later? And so that's why they think that it's important to have deconfliction. And we just had this incident happen recently where we had a person who filed a complaint with OPA and filed one with us. And while we were investigating it, that person did mediation with OPA, with the Mnpd. And we weren't notified, and so we weren't able to get in touch with the person. And so Mr. Clause reached out to OPA, and they had mediated the case and closed it. And then we still had an open case, and then we finally were able to reach the complainant, and the complainant had decided to close the case with us, but we had no notification of it. And so I think that this part of the deconfliction and just having these conversations is important, so that we aren't, working on cases that have shut on one end, or, a person has decided that they don't want to, that the mediation was successful and they don't want to move on. So any questions about that part? Okay. Moving to section 8, administrative leave and alternative duty assignment. I don't think that there were any changes in section A or B. And so the next section, hold on, section 8. Yes, I'm sorry, there was changes in section 8. In section 8, in A, there was a change. Let's see here. There was a change where it says departmental. We added the public. It says department or public safety, and it took out of anyone and then put in of request. So it reads, let me read this section. The director has sufficient reason to believe that a police officer's continued presence on the job may be detrimental to the department or public safety, and request that the officer be decommissioned, placed on administrative leave with pay, or placed on an alternate duty assignment pending a completion of the COP's investigation. So they just added public in there instead of this, and took out the safety of anyone. So we accepted that change. And then B, there was some significant change in B. So in B, let's see here. This was, so the section that we wrote in B was changed completely. And this was some new language added. So the language in here that was changed was mostly centered around the 5 calendar days. So what this reads is the department will provide a written response advising of actions taken in response to the director's request as soon as reasonably practicable based on the facts and circumstances of each case, and including the seriousness of the circumstances and or the urgency surrounding the request. Because as we were talking about this in our first meeting, you know, I initially had this changed to 2 calendar days. And because my concern is if there was something that happened, and I used the instance of what happened up in Minneapolis, and my concern was that an officer could still be, you know, which, you know, God forbid that happens in Nashville, that an officer could still be on, you know, they are still kind of doing their investigation, but the board would want that officer immediately decommissioned. And so, you know, I was concerned that we had on in there 5 days, and you know that we had to do a written request, and there were a lot of stipulations around us making this request. And so they added this language, which I was fine with, including the seriousness of the circumstance and the urgency surrounding the request. And they kept the 5 days because they said they could be like, this could happen over a weekend. And, you know, we wouldn't be able to get the written requests into them on time. And so, but nothing should exceed the 5 days. And so, as long as I think that the information as long as they understand that if there's the seriousness, the urgency, as long as that is in this MOU, and it is, I think that gives us the provision that we needed.
This is Andres. I think Mr. Kamaguchi has a question.
Okay.
Yes, it was specifically about the piece that you read before where they switched the language from everybody to public. So does that mean that we couldn't in turn protect another officer from another officer type of deal?
Oh, you mean in the previous paragraph? Let me go back and read it.
Yes.
Okay, COB has undertaken an investigation that the director has sufficient reason to believe that a police officer's continued presence on the job may be detrimental to the department or public safety. I'm sorry, let me read it. Or public safety. The department may be detrimental to the department or public safety, and request that the officer be decommissioned. Well, I think that the maybe on the job may be detrimental to the department. So I think that the employees would be covered under that section right there where it says may be detrimental to the department, unless you guys disagree.
This is Andres. Mr. Sweeney has his hand up.
Yes. No, I think it covers it.
Yeah. That's what
I also have a related question, but I don't want to cut off Mr. Campbell-Gooch.
No, that was all.
Okay. I'm a lot concerned about them saying, well, this could happen over the weekend and we might not be able to get a written request to that. This policing is 24 hours a day, 7 days a week. And I know that we had an issue previously about being able to get in touch with people over the weekend. But I think it's really important that we make sure that we have, and this doesn't have to be in the agreement, but it should be part of our operations, have really clear communications for how we get in touch with people 7 days a week, 24 hours a day, where it's not going to be going into a dark hole until somebody comes back and listens at something. I mean, I presume there's an operations center, there's a command center, there's some place for 24-hour a day information and reports that will get to the people that they need to get to. And if we don't have that information already with backup cell phone numbers and nighttime and weekend email addresses, I really think that we need to have it as part of our regular operations.
So to address that, I do have that information. We have a phone number for the field commander, who is, and we also have a phone number for the person who's in charge, and that the Department of Emergency Communication can reach out to. And I will say that this weekend there was an issue that I needed to address. And I just happened, I just called Mike Hagar, Deputy Chief Hagar, to get more information and clarity about a Department of Emergency Communication notification that I received. And he promptly answered my phone call, followed up with me as well, to tell me what the circumstances were. Every time that we have an issue, what we have been doing, and this is on the operational side, is when we get a DEC notification that we need more clarity with, because sometimes the notifications aren't super clear, I have always asked Mr. Clause to call the supervisor on duty at the DEC to get clarification of the notification and more information. And they have been very, very helpful into explaining to us what's happening and also giving us information on who's responding to the scene. We are on the notifications as well, but sometimes when they are putting those notifications out, they're very limited because it's a text message. And so it doesn't give you a whole lot of information. But we haven't had any problem with receiving the information that we've needed. But going back to your question, of course, I have Acting Chief Drake's number as well as Deputy Chief Mike Hager. And then I have the commander for CID, Captain Starling's number as well. Does that answer your question, Mr. Sweeney? Is that
Yes,
okay?
and if you had to give a written notice to them, I presume you can just text it and that would be the written notice to them, if you had to give written notice?
Now, I don't know about that. I'll have to get some clarity in that.
Well, I think that we should know that too, because
Okay.
it may be that there's a need, Saturday night at midnight or whatever, to make a written request for somebody to be put on administrative leave.
Okay, I'll check into that. Any other questions on that section? If not, I'll move into the resolution reports. So on section B, where it talks about the 30 days. So we were negotiating regarding that because, initially in the old MOU, it had I think it had some language that said, within reason or within a reasonable amount of time or something of that nature. And so I was concerned about having that just open-ended, language in there. And so we put down 30 days. And so as we were negotiating the 30 days, they said, well, what if we need more days? There's a lot going on. We may not be able to respond within 30 days. And I said, well, you can always ask for more time. And they were like, what if we just, we're very busy, we don't have enough time. And so they wanted the language to be changed to 30 working days opposed to 30 calendar days. And so that didn't bother me, but I wanted to bring it to you all if you have any concern about changing it from calendar to working days.
This is Andres. Mr. Kamalguch, do you have a question?
Yeah, real fast. If you can do two things. One, for me,
Yeah.
if you break down the difference between a working day and just business days, I think I know, but I just want to make sure I'm clear. And then two, hypothetically, how long would it take for them to do the process? So if it's 30 working days, what's the longest time that it could take?
Well, 30 working days gives them around, I want to say, about an extra 2 weeks. So 30 calendar days would be 4 weeks, 30 working days, 10, 50. I think it gives them, if you talk about Monday through Friday, that's your working days. And so there's 5 days in a week. So this would give them, I think, 2 more weeks. So it actually is, instead of changing it to 45 days, it gives them, it basically gives them 6 weeks.
This is Andres. Mr. Sweeney?
Yes, is working days the right term, or as Mr. Kamalguch kind of alluded to, business days?
Yeah, because I think working days might, working days for them could be, yeah. So we could say, we could ask them to change it to business days.
Yeah, I think that would be clear.
Jamel here. I had one more follow-up comment.
Yeah.
So in holding something that I think Mr. Sweeney said earlier around, and I can't really remember what the exact comment is, but it was about policing taking place 24/7, 365. So if it's based on their working days, then I think it's fine, because then that means that every day is their working day. That's what I think also was at the core of what I was saying as well.
So I guess if I'm hearing you right, Mr. Gooch, you want me to have them define working days.
Yeah, some clarity around that. I'm still holding and struggling through like expanding it from 30 days to 45 days. But yeah, like some clarity around like working days.
Okay. I'll do that. Okay. On the next section, which is the Force Review Board, and that will be section 11. The language that was added here, initially it just read the department agrees that the executive director may elect to participate as a voting member on any or all of the Force Review Board meetings. So we added language that if unavailable, the assistant executive director would take the position, would attend those board meetings. So that was the only change there, to add a person, because I mean, if I'm just not available, then we would miss that opportunity. And so I thought it would be good to have someone else be able to attend that in my absence. And the notification of critical incidents, there was no changes to that. And moving to crime scene access. So there was supposed to be a preamble for this one. Miss Hildreth, you want to talk about that? Because I didn't get it. I thought that Chief Hagar was going to send it to me with it on there, but.
Yes, thank you. Let me. So one of the things that struck me yesterday's conversation about the language was, at one point, Deputy Chief Hager sat back when we were discussing this Section 13 crime scene access. And he says, really, what we're trying to do is get you as close as possible, as early as possible. And it struck me that that language was crisp, clear, and really important. It was important because the safety language about getting somebody in, my eye can't fall on it right now, Jill, I see so many different colors. What was it about as soon as the scene was safe and secure? Safe and secure. We asked the question whether whether the term safe and secure was a defined term of art, either within MNPD policy or within policing generally, like would their accrediting entity, CALEA, have some language around safe and secure, right? And the answer was no, that term is not so defined. And to use their words, it's fairly subjective. And I think seeing where we were going to try to pin down, that's when he said, listen, what we're trying to do here is get you as close as possible, as soon as possible. And I said, could we put that line in almost as a preamble to this section to say that the purpose of the following section is to allow COB, crime scene access, as early as possible, as close as possible, as early as possible. So I think that was the language he was going to go back and give you today. Is that right?
That's correct. And he said he sent it over to Bob, to Attorney Bob Cooper. And I don't think that he's received anything back yet. Of course, Bob is really busy. So hopefully they'll get that with the preamble included and then get it back to us.
Right. I guess this is one of those places where maybe the conversation is illuminating. It certainly was for me, thinking about, well, why can't we just go in? The crime scene may not be safe. They say that when they bring the dogs in, the ones that we saw in the training, the officer said, I've been bitten before. When they come in, they're not discriminating. And so we want to have them secured. If there's a biohazard or falling debris, something like that, they want to make sure that it's clear. So when you see the range of types of issues that could keep a crime scene, air quotes, unsafe, it does become hard to quantify, and therefore the preliminary language seemed to be the best alternative.
Any questions about that? And so the next, any other questions about that particular crime scene access section? I can read to you some of the, let's see here. Hold on one second. It says in number 3, such access shall be identical to that granted to OPA personnel and sufficient for COB personnel to observe the department personnel as they investigated the crime scene. And all of that goes back, this whole section goes back to what Dr. Hildreth just mentioned. They're going to have that preamble sentence in there, or that section. And so if you guys have any questions, let me know. There was a little bit in section 3 regarding the access to, let's just say, for instance, I used the example that if there was some type of situation or some type of fatality that happened inside of an apartment, because they were saying, well, you wouldn't be able to go into someone's apartment, only the people in a search warrant if we had to get a search warrant. And I asked the question, okay, we wouldn't be able to go in because the search warrant doesn't allow us to go in. But if we were able to get the approval from, the next of kin or the person who was the owner of the place or the apartment, and they said yes, then you would have access to the apartment. So that's the section you see in 3 where it talks about, or other exception to the 4th Amendment to the U.S. Constitution. Mr. Sweeney?
Thank you.
Is there a reason why the word contemporaneous was taken?
No, I don't know. I didn't ask them about that. I can.
I mean, I don't know if identical is supposed to mean contemporaneous.
My notes reflect that, and I don't have the reason why, to let you all know what the setup is. Director Fitchard and I are seated next to each other on the same side of the table, even though we're socially distanced. When we have to confer, we scoot over. And my notes from the September meeting indicated that we accepted that, and I don't have anything else. So that wasn't something that came up yesterday. That was, Jill, if your mind can cast back, that's all I have there.
Yeah, I don't remember why the word contemporaneous was taken out. And I didn't ask. But I can actually.
No, I mean, if you're satisfied with the language, that's fine. I mean, one of the concerns earlier was that OPA got in and we didn't.
Yeah.
So if we're allowed in an hour after OPA, but we get to see the same things, is that identical? It's not contemporaneous. Or does identical mean when they get in, we get in, and where they can go, we can go?
Well, that was my understanding. I did talk to him about that, and I brought up, the situation that happened where OPA decided not to go in and all of that. And I told him that I did not want that to happen again. And so that was how we ended up having, I went into a whole anyway. We did have a pretty robust conversation regarding that, as well as OPA and you know what that means. If an OPA, if they never show up, what does that mean? So that became. I think that's how the safe and secure conversation, all of that came, and we had this very lively discussion regarding that. But I did not think about the contemporaneous, but I just need to probably highlight this a little more and think about it. And maybe as I think about it more, I can also email Deputy Chief Hagar and have a conversation about the contemporaneous part.
Well, I mean, if you're comfortable, I'm comfortable on this. And under the situation that you said, OPA, what happens if OPA doesn't show up and you guys are there? Contemporaneous would imply that you don't get in because they're not there. So identical might be the better word.
Mm-hmm.
But I was just asking what it, meant to convey. And, maybe again with the preliminary comment, as we talked about before, that in combination with this would be sufficient.
Well, I think you just brought up a good point in general because, there could be crime scenes. So, I think it goes back to crime scene comprising of critical incidents involving police officers. I don't know what scenes that OPA will show up to and what they won't. And so, I don't know what their rule is regarding which scenes that they respond to. So, but ours, for instance, where it says, in the very first sentence in A, but not limited to uses of force involving serious bodily injury or deaths or in or related to police custody. I'm assuming that they will show up to those, but I don't know for certain. So, yeah, I just need to kind of think about that number 3 a little bit more. Identical sounds fine, but I just want to make certain that it is, I want to make certain that number 3 encompasses all that I imagine it to encompass regarding if we show up to a crime scene and the access that would be given to us. Any other questions? All right, in section, let me see, there was a little numbering problem here. All right, so we go down to the training provided by the department. It looks like there wasn't a whole lot of, there wasn't any changes in here, but I did get a side note. We had a side conversation about that. And that side conversation was regarding the training. Okay. And this is, yes, training. So it remains the position of the MNPD and the COB is encouraged to participate in as much training as possible in order to fully understand MNPD functions, practices, and procedures in order that oversight functions are properly informed. If any CPA courses are missed, they can be made up as necessary. Consider the CPO schedule in-service training as a menu of courses. The use of online or video-based training, if they exist, should not be considered as a replacement for live courses. Video courses would seem to undermine the stated COB MNCO goals of improved understanding, communication, and mutual respect. The MNPD continues to recommend participation whenever possible in live CPA training sessions. The facilities not only meeting in a face-to-face environment, but offer opportunities for dialogue, questions and answers, and feedback. So that was a side note that we had discussed. Any questions about that? Mr. Sweeney?
Sweeney?
I just wanted to say with a couple tweaks, this looks real good, and my compliments to you and to Dr. Hildreth for your negotiations and for bringing this now very, very close to a resolution. And so thank you.
Thank you.
Thank you, Mr. Sweeney. Dr. Hildreth?
Thank you. It was, I think, very fortuitous that Acting Chief Drake decided that he wanted to attend because it made the numbers such that Director Fitchard could be present, and her presence was invaluable. As a board member, I understood the charge, particularly with this reopening of the Memorandum of Understanding, to make sure that the work of the MNCO staff was unimpeded, so that my concern was to look at the draft that we were charged with, but also to attend very closely to Director Fitchard's concerns or acceptance of the conversations as they went on. So we were able to do that together. I do have one technical question. If we're going to have to go back, I would like to go back to the resolution. Is it the resolution reports, section 9B? And so the conversation between the 30 days, the working days, business days. I have maybe a question and a suggestion. Comment, question, suggestion. I am wondering if working days are distinct from business days because, as Member Sweeney indicated, policing is a 24/7. So that could it be possible that an officer's work day are any 5 out of 7 days, but those 5 days may not conform with the Monday through Friday, right? So if that's the case, then the not to exceed question that I want to ask you as the executive committee, if we had accepted this working day language with the inclusion of a term not to exceed X number of days, would that be acceptable to you? And if we go by a straight 5 on, 2 off, and the twos are internal, so there's not a two on the either end of that. I think the math indicates that not to exceed 40 days would be the closest hewing of 6 work weeks. So would the existing language with the clause not to exceed 40 days be acceptable? I think we need to know that as a negotiating stance as we go back in.
Mr. Sweeney.
I think eventually we may have to address an issue regarding how the police department can deal with our resolution reports and what type of investigation they are required to conduct in order to comply with civil service, in order to impose any sanction. And for them to do that, there may be time issues that are beyond even that 40 days. Mm-hmm. And, you know, I'm just throwing that out from conversations that Director Pritchard and I have had, that, you know, whatever time period that we put in there, there may be other issues that we have to face.
Does that argue then for accepting the language that's before us right now as we wait to see? I mean, are we thinking about a strategy if we got to keep our powder dry because we may have to deal with this issue later?
Yeah, this is Sweeney again. My concern would be if we put in a maximum that we then can't enforce, and so they come back and give a report and say, we declined your recommendation because we can't act within that period of time because of civil service requirements.
Okay, this is Hildreth again. So right now, the draft before us reads, Section 9, Subsection B. Upon receipt of a resolution report, the Chief of Police agrees to review and provide a written response thereto within 30 working days, period. I thought I heard earlier in this conversation a request for us to go back and get that clarified, working days, business days. So I'm asking now, with the information that Member Sweeney is bringing forward, what is the direction with respect to revisiting this section? Is this fine, or is there something else you want done with it?
And I guess it might be helpful for Ms. Pritchard, I'm sorry, for Director Pritchard to walk us through the conversations that she had with how they anticipate dealing with a resolution report once received.
Okay, sure. So what will happen is, and it's really, if I can, I'm gonna go back to this conversation that I had with Deputy Chief Hagar regarding what their process is for discipline. So once it seems that this was just a loose conversation. It wasn't set in stone. So if my memory serves me correctly, what will happen is when they get the PRR, they will review it, and then they will have to, based on civil service rules and due process rules, they will have to conduct their own investigation. And once they conduct their investigation, and an OPA, and now there's two things that have to happen. OPA has a 45-day rule for their investigations, but I'm not 100% sure if this, you know, if a particular PRR would rise to the occasion of an internal affairs investigation. So I'm not really sure who would be I'm assuming it's OPA that would conduct the investigation. It may not be, though. That's not clear. But they would do their own investigation because they have to offer due process to the officers, and then they would have to determine, according to the disciplinary grid, what the discipline should be based on the information that they have, which could be different than ours recommendation. And then at that point, officers are afforded a disciplinary review hearing within the department. And once that has happened, if they decide an officer could accept that particular discipline recommendation or could decline it. And if an officer declines it, then there would be some sort of appeals process. And then that process goes in front of the civil service. And at some point, it could end up in front of the ALJ, which is the administrative law judge, and then back to the civil service. So it's not a very quick process for discipline unless an officer accepts that discipline.
Mr. Sweeney?
So the more thorough our investigation and the more complete it is relative to how OPA does what they do, I could see that what OPA is required to do when they receive our packet is far less than what they would normally upon verification of the quality of what we've done. And therefore it can be done more quickly than a typical OPA matter. But still a maximum period of time, I think, could prove difficult, and I don't see any particular benefit one way or the other of specifically putting in a maximum period of time that may be impossible to meet in certain circumstances. And so I think that the amount of time that's in there is fine, and then ultimately it's going to have to be addressed. But to actually cap it and therefore specifically in that way, and then perhaps draw a response by saying we have to decline your recommendation because we can't meet your stated maximum time period. Although I recognize that issue is presented under both scenarios, it might be more directly confronted if it specifically states maximum time period.
Okay.
Dr. Eldridge, I still see your hand raised. I'm not sure if you had a comment.
I'm sorry, I'm just not good at operating this hand thing, that's all.
So it seems like.
So I know.
Sorry.
Go ahead, Dr. Richard.
Okay, sorry. So it seems like we would go back and just talk about and clarify the business days. Is that where we left off, Dr. Hildreth or Mr. Sweeney? We would clarify the working days.
For Sweeney, yes, just because I don't know that working day has a definition and business day does.
Gotcha. Okay. And that looks like that's the end. There were no other changes. And so, Dr. Hildreth, did you have anything else to add to it?
No, I'm grateful for everybody's commentary.
Likewise, thank you all for your input, and we can. I think that if we can get this back to the negotiation table, I will send some of the information. I will write it up, let Dr. Hildreth look at it, and then send that over to Deputy Chief Hagar and the rest of the team, and then go from there. And hopefully they will have a document that is ready and prepared. And I don't know what are the next steps after that then, Mr. Martinez, Chair Martinez.
I'm thinking maybe we have to have a policy committee meeting. I know we have a lot of meetings this month, but if we take it back to the board in 2 weeks and there continue to be more issues to be worked out, we're just going to keep delaying the process.
No, I thought
Mr. Sweeney.
Oh, yeah.
Yeah, I was just thinking that if we can have, a final resolution, meaning they accept, final changes, or you guys have another meeting with them and both sides are acceptable with final changes, then they could come to the board in 2 weeks. If that's the next time that there's going to be a body meeting that can act. And if that time period doesn't quite work, then the special meetings that we have coming up, if it's just a matter of limited discussion, maybe we could tack it on to one of those. But whatever is the first option, once you and Member Hildreth are satisfied with the language, to bring it before whichever meeting can act and get it done and get it approved and then signed.
Well, perfect. Well, let's shoot for the 28th. The sooner the better. But of course, we've got to get all these revisions to them. And like I said, I think you're right. Talk to Dr. Hildreth and get this information updated and send it over to Deputy Chief Hagar and Acting Chief Drake as quickly as possible. And of course, Metro Legal. I think that if we can do that and if they agree upon it, we could have it ready in 2 weeks, I believe.
Dr. Hildreth.
Thank you. And I'm willing to suggest, if it is agreeable with the executive committee, that these final exchange of documents between Director Fitchard, she's sharing them with myself, and the police department, probably through Deputy Chief Hager, if that just happens by electronic correspondence and does not require another meeting, that will probably also expedite it. Again, as I've explained our methodology, I am comfortable with the observation that Director Fitchard is able to hold her own and communicate clearly with Deputy Chief Hager, and so that when she says she is satisfied, that is substantial completion of what it is we wanted to do as a board, which is to make sure that our director and her staff could work. So if we can do that electronically, just look over the documents. I will, give it a thumbs up if necessary. If we get to a sticking point, we will take it back for a meeting.
This is Andres. I think that sounds like a good idea. But yeah, if you can't agree on it, then maybe it might be a time to meet in person. But it does sound like we're at a point where we can do this over or do this electronically, perhaps. Director Fitchard, did you have any thought about that, or should we move on to the PRR? I know it's 5:30.
Yeah, I'm fine with everything that Dr. Hildreth said, and thank her. I really thank her for the confidence that she has in me in regarding this. So, yeah, I think that we can move on. Thank everyone for their feedback and input into this hopefully final MOU draft. So, yeah, I'm ready to move on to proposed resolution report, the process. And so I've been speaking with Chair Martinez regarding our PRR process, since we have a meeting coming up on the 23rd, scheduled from 1:30 to 3:30. We will present our very first proposed resolution report. In that meeting, we wanted to, I definitely wanted us to talk about the process. And so I gave Chair Martinez some insight into what I thought was what would be helpful. And he also came up with some ideas regarding how we would conduct that meeting. And so I just will let you start with that, Mr. Martinez. I think that you had really good, a really good plan of action. And so you want to start with that?
Yeah, so we were able to watch, listen in to one of Atlanta's Oversight Board's meeting where they were going over cases just like we would when we look at PRRs. So their process, which I think is a good process for us to follow, would be to begin with the chair or the executive director, stating the process that of the process, the procedure, the objective, and the standards that need to be applied by the board members when they're making their decision. Obviously, the material, all the information that the board members will be using to make their decision is going to be available to them 10 days prior, which I believe the first PRRs are now available to us. And if we need to review any documents, we can go to the office to review them. But after we discuss the standards that we're applying, we can go through a summary of a complaint and then the findings by the executive director. At that point, someone can make a motion to accept the executive director's recommendation. Someone can second that, and then we can have a focused discussion on the recommendations, deciding whether or not to accept them, to send them back for further review, or to reject them. The Atlanta board seems to handle it pretty quickly, and I guess it's going to be different according to each case that we review. One thing that we need to think about is if officers or complainants wish to speak, at what point do we allow them to speak? We do have a provision where we can allow them to speak if they request to do so. So that is pretty much it. I think it's a good first start for a system, but process for the first PR, but I'd take any suggestions, any comments on that. Ms. Ross?
I'm concerned about at what point do we allow the officer or the complainant to speak? Is it after our discussion or should it be before our discussion?
That's a good question. In my mind, I picture it after we have received the recommendations from the executive director and her reasoning behind them, but which is all information that we will have already. Definitely before we vote. So I could see it in between or during that discussion. So before, at the point where board members are going to be voting before that, so they can hear and take into account whatever statement the complainant or the officer give before they vote.
Okay, so will information be put out? This is Brenda. Will information be put out to the public as when we get it, or when will that information in terms of the case be available to the public?
Yes, so the board and the public get the information at the same time 10 days before the meeting where we will take it up. And that will be hosted on our website. Mr. Sweeney.
Along the lines that you were discussing, I think that it probably would be the best time to permit or invite them to speak would be after the motion has been made and has been seconded to accept the report, and then before we have our discussion. One question I had in that regard was, though, who gets to speak first? And, can either or both of them divide up their time so that they get a second argument? So like in court, typically the person who has the burden, and in this situation, I don't know how you would look at it, whether the complainant has the burden or the defendant has the burden. But typically the person who has the burden would get to go first and last. And then the person who's responding to that is in the middle. So are we going to split I think it's 10 minutes. Are we going to permit the 10-minute time to be split? And is the complainant going to go first? And is the officer going to go second? Always? Or will it depend on what the recommendation is of the executive director? So if the executive director recommends dismissal or recommends policy exoneration, will that affect who might speak first, as distinguished from if the recommendation is for a finding of responsibility of one type or another and the potential imposition of recommended discipline?
That's a good question. I haven't considered that. And, Director Fitcher and I discussed how in the bylaws, I think I think it's the bylaws, we discuss, that we don't have to necessarily give people the right to speak, but I think we have to think clearly or more carefully about that order that you propose. But since it's not, a hearing, it's just a statement that they give. To me, I don't know, it seems I'm less concerned about the order. I know one concern that we had when we were making these rules, I remember we talked about when, if both the complainant and the officer decide to issue a comment, and, back when we were meeting in person, what effect would the officer showing up have on the complainant, especially if the complainant experienced some sort of trauma during the incident? Obviously, we don't have that here, but we can't because we're not meeting in person. But Director Richard and I discussed, who would be, we would separate them. Maybe they would not be in the room. But as far as order, it's something that we still have to think about. Director Fitcher, do you have any input on that?
No, not off the top of my head. I think I need to think about it a little bit more. I was thinking about what they were doing down in the city, Atlanta, and it seemed like they went through the whole process before they allowed anyone to speak. And I'm not really sure what their understanding of the process was. And then they took I think they went through the process. They let the officer speak, and then I think that they took an additional. They took another vote after discussion. So I think that we need to talk about that a little bit more.
They actually have a system where the case I saw, it's not that the officer had requested to speak, it's that either some board member, I think, said, well, I think we have the officer here. Do you want to clarify this? And then the officer came on and, gave an explanation of something. And then the board members were able to follow up on his explanation, which would not be the case in our process. Like, I don't think that board members are able to ask questions of either the complainant or the officer.
Right, because we're not conducting a hearing. We are just, allowing people
Right.
to share some information about the incident.
I'm going to go to Mr. Campbell Gooch.
Yes, I think this conversation is so interesting, and I don't really have a direction, but I do have like a basic comment. So many times with our systems, we center punishment. So we center how much time is someone to get, how many years are they going to spend in prison, how are they going to be punished, even down to how long people will be suspended from school. And so I just want to hold and center that I think it would be great for the process if we center the harm that was committed versus actually centering the punishment. And by centering the harm, we can actually give all parties an opportunity to heal. But I know that's an abstraction, but I just wanted to say this here while we was having this very great conversation.
That's a good point. And it's something to consider as we format and develop the PRRs, where how much that is discussed and how much that is centered, definitely. Mr. Sweeney, your hand is still raised.
Mechanical question. With us doing it remotely and only participants, meaning us, are able to speak, how is that going to be arranged for the complainant or the officer to actually speak?
So I was thinking about that too. I was thinking that they would be able to, since you're not asking them questions, and they're just commenting on what is in the PR or what the incident was about, that they could actually do a pre-recorded message and we just play it like we do any other public comment. That's one suggestion. It might not be the best suggestion, but that's, one suggestion.
Can we also do a telephone call like when we've done the public forums?
Well, the difference so in order to do those types of forums, then what we would have to do is we would have to ask MN to do a live call-in for just those two people, because on the special call meeting, it's not open for public comment except for the complainant and then, of course, the officer. And they only have trying to schedule that around MNN. I think would be more difficult at this point, simply because we would have to have 2 or 3 of our staff to meet over at MNN. MNN will have to, it's not a very easy process. It takes a whole lot of technological assistance to put those on, and they would need a certain amount of time to be able to do that. And I just don't know if we're going to be able to do that in our short period. Especially if they need a response within 5 days, right? And that gives us only a 5-day period to ask MNN to schedule this really big live meeting. So, I mean, we could put them in as a participant, when they come into the room, and then, they could come in as an attendee and listen, and then maybe we could bump them up into the participant level where they would be able to speak. I mean, that's another option.
Can we have it so that a person is in a participant stage, but they're not admitted until a particular time?
I don't know. I know that we can do that on Zoom, on the Zoom platform, but I'm not really sure if we can do it in WebEx, but that's a good question and I'll ask about that.
Yeah, I think maybe that would be a good idea to figure that out. I think that there are very few people who are going to be able to make a 10-minute recorded call. And also, depending on the order of who's speaking and all like that, one person would lose the ability to hear the other person speak if you do by pre-recorded calls.
This is Andres, but I don't think that it's necessary for one to hear the other speak. And that makes me, if we're talking about order, if we have pre-recorded statements, then I mean, it could be that it's not fair that the person who's going second has the ability to respond and argue points that were made person who spoke, and the first person who spoke doesn't have that opportunity.
That was one of the reasons I was asking about dividing up comments. I mean, I don't think that, at least in the abstract, I don't think it would be appropriate to tell somebody they can speak, but they can't comment on what the other person said if the other person commented upon the report and why they didn't think the report results were, accurate or shouldn't result in, whatever the recommended decision was. I mean, I presume that at least some people who speak in response to reports will, because they have some opposition to it.
Well, I think that we can guide that as well. I mean, I thought that this was just going, I guess I hadn't thought about that. I was under the assumption that when we allow people to speak, they're speaking in general in reference to the incident and what they perceive happened, and not like having this dialogue back and forth regarding, what someone else said and, what they said on the phone call, and it becomes very arbitrary. I'm concerned about that. And as for having people listen in, I mean, if it's live streamed and you're listening, you're going to be able to hear the calls regardless, So whether there's not a way that we can separate people on, and they not be able to hear what's happening. And this is being broadcast via, it's right now it's streaming on MNN. So I don't know if that helps.
I mean, I would presume that people are going to use this opportunity to speak in a number of different ways. That they will use it to, revisit the incident one way or the other. Or they will use it to challenge the report by saying that, it wasn't thorough, or there were other witnesses that were never interviewed, or that they misunderstood something that was said, or it's not fair, or they weren't treated respectfully. I mean, I presume there's going to be a wide variety of what people are going to say, but that they're probably going to speak if they think that the report in one way or the other does not reflect what they think it should reflect. Because otherwise, I'm not certain why they would speak. I mean, it's not to receive any new evidence.
I would add that.
It's not receive any new evidence. But
Right.
There may be various things that they say that would give the board pause and say, you know, we need to look at something more thoroughly, or, you know, they've come up with this late witness and maybe that person should be talked to too, or, you know, whatever. But I mean, I presume there's going to be just a wide spectrum of what people are going to want to tell the board.
Well, the other thing is, you know, they have to give a reason when they want to speak prior to be given, before the approval is given. So, you know, we will have some indication on what that is before they are, you know, before their opportunity is approved.
I would add that that they are giving a comment and preparing a comment in response to the PRR and not in response to the other person's comment.
Right. I agree with that.
I do, but I think it's, as a practical matter, it's going to be very difficult to kind of edit people as they speak. And depending on who's speaking, they might consider that to be unfair or trauma on trauma, because now there's this public board that doesn't want to hear me. So I think I think it's a very, very difficult issue to navigate. And my presumption is that people will pretty much be able to say what they want to say, and then it will be a matter for the board to consider what significance that has to the ultimate decision that the board has to make.
Well, there's two things here. It says that would be given on a very rare instance, right? The approval to speak, number one, and number two, that the board is going to base that the report is based on the presumption of correctness. And so, I mean, that's something that you all as a board will have to decide on, whether or not you want to give permission for people to speak regarding the PRR. What we don't want to happen is that we have, you know, a very there's an opportunity for people to there's a continued harm, or there's a, you know, there it becomes a very disjointed and confusing time, because the PRR is very straight and very clear and concise. And so that's something that we definitely...
Director Pritchard?
Yes.
Yeah, this is Andres. Do the rules or the bylaws, do they state who approves whether or not, or who gives somebody permission to give a comment, or who makes that approval?
Yes, let me pull that out. Hold on, I have it here in front of me.
You do.
It's the board chair.
Oh, okay. I thought it was
the chair. Based on their argument that they should be allowed to speak.
So it's in our rules. And Todd, do you want to help? You want to help in that and let him know what the rules say regarding that? I'm looking for it.
Just 1 second.
Yeah, here we go.
It says that permission will not be granted regularly, but the board chair may grant permission for brief comments by both if requested by either and granted for good cause shown, not exceeding 10 minutes each and at least 2 calendar days before the board meeting. The complainant and the accused officer will be notified of the chair's decision. That's in section 2D1.
Thank you, Mr. Pinkley. Mr. Sweeney?
Yes, Director Pritchard, if I recall correctly, you had a conversation with an attorney for the FOP about the ability to speak at these PRR considerations.
Mm-hmm.
Can you share that?
Yeah. Wow. Let me see. Chris, you want to help out with that? I don't want to misquote Mr. Byrd. If you can recall what he said. It was...
Sure. I remember that one of the things that he had asked would be that people would be able to speak at the hearing or at the presentation, since it's not, I don't know why I call it a hearing, but at the presentation as more of just a way for them to get out anything that they might have that contradicts what's in the PRR. So I think his stance was that it wouldn't be on a rare occasion and that it would be pretty much open whenever the party wanted to. Is that what you remember too, Director Fitcher?
Yeah, it was, I think that pretty much sums it up.
And didn't he also raise a due process issue in the event that there wasn't a regular right to speak?
Yes, he did talk about due process. Did you remember that too, Chris?
I do.
Yeah, he mentioned that they have a process, and that's the same process that I mentioned to you a little while ago regarding what MNPD's due process is and how it, you know, goes to the civil service, and they have a disciplinary review. It was the same process. They both that Deputy Chief Hagar spoke of as well.
This is Andres. Mr. Sweeney, do you remember why we wrote in that we wouldn't be issuing permission to speak regularly?
The thought was that the parties would have a full opportunity to present whatever they wanted considered during the investigation process.
Right.
And since we're hearing on a recommendation with a presumption of correctness, that since the person already had the opportunity to provide information, that there wouldn't be a general need to do it later. Now, I do understand that Mr. Byrd had said that he didn't think that the officers had a fulsome opportunity to speak during the investigation.
So our next steps here, I mean, we need to decide.
Oh, one other thing I wanted to say, I'm sorry, Mr. Martinez. Yeah. They, you know, I think also the due process level comes in at the department level, because the department level is going to have a hearing. I'm sorry, they're going to do their own investigation more than likely, and then if they decide to give out, discipline, then that hearing would happen, or their disciplinary hearing, or however they do it, would be on that side as well. So I just wanted to remind you of that.
So next steps here.
Can I say one other thing?
Sure.
So this is Sweeney again. Although technically, legally, I agree with Director Fitchard as to where the due process requirement comes in. I don't want us, and we shouldn't be in a position where we make a recommendation and it goes to the MNPD and they say that we're not going to accept your recommendation because we don't think that you gave due process. We don't think that you gave a fair opportunity for the two parties to both be heard. So, I mean, I don't think that there's a requirement as a matter of course for everyone to get to speak in order to satisfy due process. But I do think that however we decide, we shouldn't decide it on the basis that we don't have an obligation to give due process. Because I think that it is our desire and intention to give everyone notice of the charges and a fair opportunity to be heard before a decision is made, which is due process. And I think that we have the best opportunity to have our recommendations be accepted or to have a more limited further investigation by OPA because we've done such a good job that will then encourage an acceptance of our recommendation. And I don't want us, and there's no reason why we should be, viewed as taking shortcuts because we don't have to comply with the process.
Yeah, I agree with that. I think we need to be as fair as possible. But for this first one, if either the complainant or the officer want to give a statement, we first need to figure out the technology, the accessibility of it, and then the order that they will give their statements in. Is that right, Director Pritchard?
Sorry, can you repeat that?
We still, for this first one that we are going to consider, in the case that the officer or the complainant wish to speak and are approved to, we still need to figure out in what way they will give their comment, whether it's live or it's pre-recorded, and what order.
Yes. Yeah, I had that. That's what I wrote down. So yeah.
Mr. Sweeney.
Yes, as we're trying to find our way, and for the purpose of having a specific proposal to discuss, I would suggest that the complainant, because they're the ones who brought the charge, speak first, and then the officer, since they're the respondent, speak second. If we find that procedure doesn't work, we can change it as we go forward with others. But as a place to start, I would suggest complainant and then responding officer.
I think that's a good place to start. Ms. Ross?
I also think that's a good place to start.
Great.
Okay.
Any other comment or question about the PRR meeting upcoming? If not, Mr. Campbell-Gooch.
I wanted to say, like, some of this we're not going to get right until we actually experience it and figure out what's wrong. So
Right.
I'm looking forward to just like figuring out, trimming down the process, coming back to the board and continuously like trimming it down to the point where we are working lockstep. The community knows what to do. Officers know what to do, and everybody involved has a on target and ideal expectation to the process. So, like, I think we're working lockstep and in the right direction.
Thank you, Mr. Campbell-Gooch. Yeah, I think it's going to take some trial and error.
Yes, it does. Yes.
Can I make one other suggestion?
Yes.
That when you explain the process to us at the meeting, that you include in that explanation one for the complainant and for the officer as well, if they've been allowed to speak, and to let them know that all of the evidence that we're going to consider is the evidence that's in the report, that this is not a time for us to be able to consider other evidence, and that we welcome their comments, but we just want them to understand how this process is going to work. And I'm sure there's a much better way to say that than I just did.
Right. Yeah, I understand. Thank you. Director Fitchard, I think if we still have Dr. Villiers on the line? I know it's late.
Yeah, he's still here. He's hanging in. So yes.
Yes, I'm still on the line.
All right. So we have a policy advisory report. There was a change to it after the public comment and the public hearing that we had last Wednesday. And so Dr. Villiers just wanted to talk about those changes and give you some insight into why he made the changes. And if you guys have any suggestions for him. So Dr. Villiers, you have the floor.
All right, good evening. So we held the public hearing on the policy advisory report last Wednesday. We received 3 substantive comments on it, and we used those comments in order to revise as is part of the process that was laid out. The result is that we have made several two changes to 2 recommendations. Those are outlined. There were 3 documents that I believe were sent to the executive committee today or yesterday. That one is the updated report. The second is a legal red line comparing the drafts. And the third is a document that goes through every revision and the rationale behind making changes. And so those should encapsulate everything that was changed. We also added, based on a community member suggestion, a 7th recommendation to have quarterly or monthly reporting through an interactive dashboard, which I think it was just consistent with how other cities have responded to consent decrees. So I think that's the main update, and happy to answer any questions.
Thank you, Dr. Villiers. Are there any questions on the changes to the policy advisory report? There are none. Then we take this up at the Inc.
So I did have one other thing to interject in regards to policy advisory reports. So we have 2 policy advisory reports that are still outstanding. One is our immigration report, and the other is the 8 Can't Wait reports. And so I just wanted to touch base with the executive committee and have Dr. Villiers he can chime in. You can chime in, Dr. Villiers, when you can. Those reports are still outstanding, and I just wanted to know if the executive committee would want, or what the next step is in those. Are you all okay with us forwarding those reports to Acting Chief Drake to get some response? Of course, sending all the responses that we received from Chief Anderson to him as well, so that he's aware on where it ended. Or how would you like us to move forward? And Dr. Villiers, can you talk a little bit about what's still outstanding, if you can recall, on those reports?
Sure. On the immigration report, we had been in discussions with Metro Legal and Mnpd about whether it's possible for the department to have a policy that discourages officers from asking about immigration status in context of state law, where law enforcement officers cannot be prohibited from asking about immigration status. And so we had been in discussion with Metro Legal on that topic. On the 8 Can't Wait report, one of the 3 recommendations was accepted, and we have not heard a response on 2 of the other 2 responses, 2 other recommendations. One of those 2 recommendations is reiterated in the current policy advisory report on consent decrees.
Okay. So my question would be to the executive committee, how do you want us to proceed with this?
Mr. Sweeney.
Well, it sounds like one's a legal question, and that should be pursued with Metro Legal. And the other one deserves follow-up with the chief. I would suggest that communication to the Deputy Chief Drake to advise him that these 2 are outstanding and provide him with copies of them, and to advise him as to the status of each, and let him know that after we hear back from Metro Legal, we'll be back in touch with him as appropriate, but want to give him a heads up and keep him, informed in case, he didn't know. And then as to the others, that they're outstanding, and, give some reasonable time for a response.
I think that's a good idea. If we could work on sending those to get a response, so then we can follow up on that. How many days do they have? Does the chief have to respond?
Well, that's in our old MOU, the one that we're operating on currently. It just said within a reasonable amount of time. We haven't made the decision on our new MOU, Mr. Martinez. That's the one where we talked about either 30 business days or
right.
30. Yeah, so we're still working on through that.
So yeah, I think let's go ahead and send them to him, and not delay the process any further, because we also don't know, how much longer he will be in the position unless he continues.
Okay.
Is that anything that we have to vote on?
I don't think so.
Okay. If there's nothing more on that, I think we can move on to new business and announcements.
So I have some new business. The PRR for our specially called meeting is we were able to get the database up and running. And I'm gonna let Dr. Valier, if you're still on the line, can you talk a little bit about that process? I am sending the board members the PRR now or after this meeting, but Dr. Valier can tell you what we have online.
Yeah, so we have we updated the Community Oversight website with a page on proposed resolution reports. That page describes the process of those reports and their process through the board. And it also contains a spreadsheet that links back to the open data portal for Nashville. And we are using the open data portal as a way to store documents for that, the PRRs that will be released, as well as the responses from the chief of police. And as we talked about at the previous PRR meeting, that is a sortable list, and so people will be able to view the available reports and sort those by date or by case number. And we have a process in place internally on how to update that with redacted, non-redacted as the case, cases close and response letters are posted. And we have those steps written out to make sure that that is maintained in accordance with the process that was outlined. So you all should be able to go to that website and see that and see those updates.
Okay, thanks. And so that's all that we have in regards to that. Today starts the 10-day process. Our specially called meeting is on October the 23rd at 1:30 p.m. And the officer and complainant are both have been notified. And that's all I have.
Thank you, Director Fitchard. Ms. Ross?
How many cases are we hearing that day?
Just one.
Any other questions, new business announcements? If there's nothing, then I will take a motion to adjourn.
So move.
Second.
Thank you, Mr. Campbell-Gooch. Thank you, Ms. Ross. And I will do any focused discussion? I think so. So roll call here. Mr. Campbell-Gooch?
Aye.
Ms. Ross? Was that it? Couldn't hear you there.
Aye.
Thank you, Ms. Ross. And Mr. Sweeney?
Aye.
And I vote aye as well. It's 6:19. With that, we will adjourn the meeting. Thank you very much.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information about this and other programs, visit nashville.gov.